If they think, if the BJP thought that we had lost confidence, they should have moved a motion.
That is because of Bommai, which said that it's only the floor of the house.
That's correct. So you move a no confidence. How? Right, absolutely right. But they are still the Shiv Sena. That question will still have to be answered. What is that? What are the 39? They are still the Shiv Sena. As a constitutional principle, it doesn't arise. Don't give that discretion to the governor. You will have toppling governments every other day. One is subject to judicial review, the other is not. Difference is one is subject to judicial review, the other is not.
All are subject to judicial review.
No, Malas. But once a new government is formed, Malas, if we
So once there is an existing government, according to you,
yes,
which
yes.
this was not a government formation for the first time.
That's correct.
Then the governor, short of a no confidence vote, which is brought on the floor of the House,
Yes.
the governor must ensure that the existing position continues until somebody brings a no confidence vote.
That's the only way. Now your lordships have laid that down. No longer parading, no longer comparing signatures, all that is over. So if they think, if the BJP thought that we had lost confidence, they should have moved a motion.
That is because of Bommai, which said that it's only the floor of the house.
That's correct. So you move a no confidence. How do these issues come in at all? There's no discretion.
So according to you, as a matter of principle, absent a motion of no confidence,
That's right.
the governor must continue with the existing position.
That's correct, because there's an elected government.
All right, we got it. I understand
Right.
what
Now, this is much worse, that he recognizes the split and administers the oath of office.
And thereafter, the floor test was subsequently.
Yes,
That is
On 4th,
yes, on 4th,
3rd or 4th.
including those 39.
But there, so far speaking by myself, can the governor, correct? Because under the 10th schedule, it is for the speaker to take a decision,
Right.
correct? Can the governor, correct, on his own, without any disqualify, the speaker can take cognizance that they are disqualified?
Your lordship is right, absolutely right, but they are still the Shiv Sena. That question will still have to be answered. What is that? What are the 39? They are still the Shiv Sena. So then he recognizes the split. That's the problem, Maharaj. That's why the 10th schedule, that's why the whole paragraph, this is the issue. When 3 was eliminated, it was only for the purposes, deleted, it is only for the purposes, majority or minority, you can't destabilize an elected government. And constitutional morality was the linchpin, Maharaj. So Maharaj, and that's why I told your lordships, ideally the governor should have said, no further action, get your disqualification decided, then I will see. I told that to your lordships earlier.
But suppose the speaker doesn't decide.
No,
But listen. Suppose disqualification questions are not decided at all. In the meantime, the governor is satisfied. Correct?
Can't be.
No. He, on the basis of the material
He
correct?
can't. Well, that's not his job. It's the no confidence motion in the House. How is the government satisfaction after election doesn't arise? Well, I'm sorry. As a constitutional principle, it doesn't arise. Don't give that discretion to the governor. You will have toppling governments every other day. First the ED will go, then the CBI will go, then the governor will exercise discretion and governments will be toppled. How's the discretion?
It's a speaker versus governor. Speaker versus governor, as I had said. So now the flip side of it is that without any chance for all that to be panned out, the speaker shows over anxiety to take up the matter and immediately disqualify all those who are intending to.
Well, the speaker should decide. Your lordships have now said within 3 months. This is the judgment of this court, that within 3 months, speaker must decide. Normally earlier, but latest within 3 months. Justice Nariman's judgment was in Meghanchal matter.
No, I was telling you about the flip side of it is, on the one hand, yes, governors over anxiety saying that, okay, you prove the majority.
Right.
On the other hand, we have a speaker exercising that discretion and says, now come on, you immediately show, I will disqualify all of you. So these are the two constitutional
But there's
authorities.
One is subject to judicial review, the other is not. Difference is one is subject to judicial review, the other is not.
All are subject to judicial review.
No, Maharaj. But once a new government is formed, Maharaj, if he calls for a trust, new government is formed, Maharaj, what judicial review?
True. Remedy is a different matter. I agree with you that
Yeah.
there is a remedy,
Yeah.
but really speaking, it's there.
And Mullahs,
What we need to interpret is the scope of the jurisdiction of the governor and the scope of the jurisdiction of the speaker also.
the speaker, of course, the scope of jurisdiction is clear. He has to decide the matter.
Scope and extent.
The order of preference suggested is an alliance of parties that was formed prior to the elections. Kindly just mark the word alliance. The largest single party staking a claim to form the government with the support of others, including independents. Then a post-electoral coalition of parties with all the partners in the coalition joining the government. Kindly mark the word coalition of parties, post-electoral coalition of parties. And then a post-electoral alliance of parties with some of the parties in the alliance forming a government and the remaining parties, including independents, supporting the government from outside. No other exception is there. Now, kindly mark this, that it has to be a party supporting for the purposes of the floor test. There has to be an alliance as a matter of law. Therefore, the governor cannot exercise any discretion. He must ask what party you belong to. I'm done with this issue, Malaj. Now, just two more issues and I'm finished, Malaj. Number one, your lordships have not noticed that Gugavale was appointed as the whip from Assam. If your lordships agree with me as a proposition of law that the whips cannot be appointed in this fashion, ultimately the speaker, once that government is formed on the 3rd, recognizes Gugavale. Right, Manoj? And then I am issued, our legislators are issued a notice for disqualification on the 8th of July. If your lordships agrees with my proposition of law that whips cannot be appointed in this fashion, then our notices should be quashed by this court.
Subsequent notices.
Your notice.
Under 2(1)(b) or 2(1)(a).
Yes. Against us, notices against us.
Correct.
Yes, 2(1)(b).
2(1)(b).
Yes.
But they are virtually non-issue, right?
No, it's not a non-issue. There's a notice of disqualification against me because they say Gugavale gave a whip.
You are right. You are right.
So, it's a live issue
The
for us.
legislators whip,
Correct?
not the political parties.
Yes, legislators whip. So, therefore, my request to your lordships is that notice for disqualification must be struck down by your lordships. If your lordships, of course, agree that you cannot appoint a whip from outside.
But that's the direct challenge also.
Yes, we've challenged that.
In your
That you have challenged.
38.
Yes, I've challenged that, Melissa. Now, one more point, Melissa. Your lordships, Melissa, in September, when a whole petition was argued that the election commission should not proceed, your lordship said no stay. Fine, Melissa, no stay. We went back. Melissa, what happened was we thought, and this is we interpreted the order to mean that the proceedings before the commission should go on. Fine, Melissa, let them go on. The problem arose that we told the commission that if you take this test of organization and representation in the legislature, you necessarily will have to include 38 or 39. And therefore, if you take that into account, your outcome, your result may be that they get the symbol. But that very matter is pending before the Supreme Court about the disqualification of these 39. So please stay your hands and let the Supreme Court decide. Now, I personally feel, Millers, that was not counter, it was not antithetical to your lordship's order of stay. After all, the Election Commission has also to decide in accordance with law. The result was, I mean, this is again the sad part of it. The result was the commission says, I'm not going to bother about the organization. These 39 members are majority, therefore they get the symbol. In fact, your lordship's order was misused.
But we are not considering the validity of the order passed for the election.
No, I'm not asking, Malas. I'm really saying the commission said, the High Court said, Supreme Court has said no stay, therefore they have to decide.
That is to be tested in those proceedings, no?
No, that's not, but kindly see the consequences, Malas. Kindly see how we are hurt. That's why the reference, what is the scope of powers of the Election Commission in respect of determination split within the party. Malas, I'm not, your lordship's passed, Malas, rightly so, according to me, that let the commission, but the commission doesn't have to, can't disregard basic principles that you are giving symbol to a party on the strength of those 39 whose disqualifications are pending.
And that issue is pending before this.
That's pending. And I said to them, please stay your hands. They said, no, but Supreme Court has said that we have to go on. That's how the symbol is given. See that injustice caused to us. I just make the point, Mullah, and not go further.